Welcome to our very first lecture in Constitutional Law 2 for the second semester. So this lecture, we are dealing with a broad theme, which will spread over one or two lectures, depending upon how fast we're able to progress. So we are addressing the topic or the major thematic area, evolution of Ghana's constitution. So the history, the context, and the evolution trajectory or path of Ghana's constitution. So throughout the course of this lecture, we shall be exploring issues including the constitutional structure in pre-colonial times. That is, what were the governance arrangements that were in place before our people came into contact with the West, before our people came into contact with exotic model of governance through the colonial enterprise and its architecture. We will also be exploring evolution of the statehood of Ghana. By now, it is right for all of us to appreciate that the country we call Ghana, and for that matter, the Ghanaian people, has not always been so. It started at a certain point in time. So before that point, when we came to have the emergence, the establishment, or the creation of the modern statehood of Ghana, what was the situation like? And how did the evolution, how did the development took place? We will also be exploring major constitutional epochs of the colony. During colonialism, a number of experiments were made as far as constitutional arrangements were concerned. Some of these experiments were not because of the benevolence or the generosity of the colonizers, but because of agitation from the colonized. And the various agitations culminated in incremental response to the demands which were being made by the colonized. And that is why various constitutional changes will be encountered, all aimed at trying to address some of the governance concerns of the people who have been colonized. So we'll be exploring that. We also delve into the major demands of the opposition ahead of independence. And this is quite significant because just before we attained independence, there were a number of dilemmas, number of governance choices or options, which the country to be known as Ghana, about to attain independence, had to confront and settle on one or the other. And you notice that the kind of governance model which we have experimented and culminated in the 1992 constitutional tablet has had a certain checkered history. And that history is also linked to the opposition elements to CPP just before we had independence. So we'll be looking at that. And of course, we also look at the highlights or overview of post-constitutional, post-independence constitution. When we attained independence in 1957, 6 March, we've encountered or experimented a number of constitutions. So we'll be looking at that, the features of each of them. And we will, of course, look at the intervention of the military in our body politics. When the men on the horseback, to use the words of Professor Theo Modibokran in his famous work, Law in Need of Development, referring to military intervention in politics. Only use the expression, the men on horseback. And the men on horseback actually assume the reins of governance. What constitutional arrangements, quote and unquote, do they put in place to shepherd governance for the period that they will remain in office or they will remain in force? Now, it is important that we discuss this thematic area, evolution of Ghana's constitution, because, as you recall from the well-known case, Tufo versus Attorney General, and the words of SOWA GSC, which has become a cliche, which inter alia says that the constitution of the people is not an ordinary document. The constitution of the people mirrors their history, their past, their aspiration, their search for better society or better development. So the constitution reflects where the people are coming from, what they have encountered before, what did not work for them, for which reason they considered it necessary to make changes or make adjustments, tweak it here and there in order to address some of the problems or challenges that they have encountered. And that is why we cannot just ignore the historical context of our constitutional evolution and just start discussing the actual constitutional arrangements under the 1992 constitution. That will be inadequate because the things that we have in the 1992 constitution emanated from a certain background. And that is why it is pertinent that we immerse ourselves in the history, the past of our governance arrangements. Therefore, at the end of this class, it is expected that students will have an appreciation of the evolution of the country's constitution from the colonial period through to the independence and thereafter. Students are also expected to be able to briefly describe the main features of the pre-independence and then post-independence constitution and note the ways they differ from or are influenced by preceding constitution. And that is a very important point which we need to underscore. Particularly so, even as individuals, right? As individuals, where you did a particular enterprise, it collapsed, and want to set up another enterprise or project, you have learned lessons from the previous one so that you calibrate or you adjust, you arrange the new one in such a way that the problems which were encountered in the failed enterprise or the previous one will be eliminated or will be seriously ameliorated or diminished, as it were. And that is why we need to take this thematic area serious. In that regard, some issues we'll be considering include use of the Constitution and law to perpetuate colonial rule. It's very interesting, how our colonial experience has been. It's not the case that the colonizer just used the force of arms to impose themselves on us and took over governance authority and started governing our people. In some respects, one may make an argument like that, but That is not the full story. It's just an aspect of the story. More importantly, because the colonizer is coming from a certain governance tradition, a certain type of society in which the rule of law, for example, was cherished. The colonizer needed to satisfy its conscience by trying to give legitimacy to the governance arrangement, which they introduced as part of the colonial architecture. And that is why we'll be exploring the extent to which the colonizer or the colonialists made use of constitution, made use of law to perpetuate, to actually continue their colonial rule. And as a matter of fact, you appreciate or you have appreciated from your various reading around the course and general history of Ghana that the independence of Ghana itself was not attained by force of arms. It's not the case that a war was fought to actually defeat the colonizers and then we declared independence. No. You will notice that a law was even passed at some point in the Westminster Parliament, in which the colonial government was giving concession of its readiness to allow independence to be attained. So as we move on, you come to appreciate this better. Another issue to be explored, the piecemeal introduction of natives into colonial administration. You will notice that initially, the colonialists were running the show, but then they soon realized that without involvement of the people, the colonial administration was not going to be successful. So in some colonial areas, the colonial administration on their own realized the need to involve the colonized or the people who have been colonized. You might have heard of Lord Lugard dual mandate in northern Nigeria, and also in some respects, maybe you come to some parts of our country where they will introduce the indirect rule, by which the colonial administration, they are very much in charge, except that they are using the natives to serve as a front in dealing with the people. Now, that is an aspect of how the natives got involved in colonial administration. The other aspect is where the intelligentsia are like the elites, the indigenous people, the colonized people who have had some benefit of missionary education and so on, and they were enlightened about the ways that the colonizer was doing things, and for that matter, could stand up to them. So they began to mount pressure and say that you need to involve some of us in the architecture of colonial administration. Now, that was done incrementally, gradually, slowly. And another point we need to note at the very outset is that the evolution of our constitution has not necessarily been coherent. That is to say that it is not really the case that there was a grand design on the drawing board regarding how our constitution was to evolve or develop at every stage in that order as if there was like a master plan, well thought out, on the drawing board or something like that. No, that was never the case. So there was no coherence, there was no coordination, so to speak, as far as the evolution of our constitution is concerned. And for that matter, it could be argued that the evolution of our constitution was largely accidental and spontaneous. Accidental and spontaneous in the sense that the various changes were precipitated by certain development, not because hitherto or long before those developments actually occurred, there was a master plan to say that at this stage it should be like this or it should be like that. That was not it. So that is one point that we should keep in mind. It is also worth noting at the very outset that there was a continuous existence of colonial legal span in independence constitution. If you examine the independence and even the post-independent constitution critically, you will notice that there were some important traces of colonial legal arrangements in those constitutions. And we also notice as we move on in exploring the evolution of our constitution, we come to appreciate that the constitution was also used to settle political problems. And in the various historical narrative, you come to appreciate that anytime there was a major political problem, uprising or agitation, some disturbances occurring, boycott, strikes, and so on, the colonial government will probably set up a committee to probe into it. And the part of the probing will unravel the observation that the remote cause of this problem is because of these constitutional issues. And for that matter, if we are going to redress these problems and avoid recurrence, we need to tweak, we need to recalibrate the constitution as we have in order to accommodate these demands or these concerns, which have been outstanding for some time. So constitution making was actually used to settle political problems. Now, these issues we are flagging at the very outset should be at the fore of your mind as we go along. Now, we would like to delve a little bit deeper into constitutional structure in the colonial and the pre-colonial times. So when we say the pre-colonial times, that is the period before the introduction of colonial rule in Ghana. So the first point to note is that we had no unified pre-colonial structure, but heterogeneous traditional constitutional processes which were in place. What do you mean by that? That is to say that before the coming of the colonialists, the colonizers, and the establishment of colonial administration, there was nothing like a uniform structure for governing the territory, which subsequently will be identified as Ghana, or initially Gold Coast and now Ghana. We didn't have any homogeneous or didn't have any unified structure for governing the whole of the territory. But we rather had heterogeneous traditional constitutional processes, different traditional constitutional processes. And these traditional constitutional governance arrangements were very much similar to the various ethnic groupings which we had. And you will notice that different ethnic groups had different ways of governing themselves. They were not uniform, but you could discern some general characteristics which appear to run through the various traditional governance systems among the different tribal ethnic groupings that we had. So we would like to highlight some of these commonalities which one could discern in the traditional governance arrangement which existed before the introduction of colonial administration. So first, chiefs and kings serve as executive heads of the kingdoms and the chiefdoms, with the elders as advisors in council. So it was very common to go to the various traditional areas to see a chief who wielded what in modern constitutional parlance would be called executive authority. So the chief or the king wielded executive authority. And of course, the chief had advisors in council, and these were the various elders or the sub-chiefs, as it were. We could also discern in the various traditional governance arrangements in the different ethnic groups existence of procedure for the passage of rules and regulation, which often included consultations between the monarch and the family heads and elders of the states. So there was it's not only the chief who served as executive head or the wielder of the executive authority. There were also clear processes or procedures by which rules, regulation, or norms for governance were crafted. And these rules or these decrees did not just emanate from the chief, just like that. Before being promulgated, before the chief will publish it, there will have been prior consultation with the relevant elders for some consensus. Of course, all those things are not binding on the chief, except that in the traditional setting, the chiefs are wise and they pick ideas from what various councillors or advisors will be suggesting. In the traditional governance before the colonial administration or the colonial times, we also noticed that the chiefs serve as judges, adjudicators of disputes. So they serve as judges, except that the way and manner the chiefs went about adjudication was somewhat different from what pertains under the adversarial, if you like, litigation system introduced by the Westminster colonial model. Now, the chiefs, in serving as judges, always sat in judgment with counsel. So the chief had councillors, elders, who act as assessors with authority to deliver punishment for breach of customs. even in modern times, those of you who have been to various traditional palaces or when the chief sits in state to hear and settle dispute, you notice that it's not the chief alone. The chief is surrounded by other sub-chiefs or elders who will all help him in listening to the case, the various testimonies and all that. And after that, they will have deliberation and a consensus is built before an award or judgment or decision is delivered by the chief. In most of the traditional governance system, we also notice existence of ASAFO and Ahimfie police who serve as security of the states. So the chiefs actually had some organized institutional coercive element to deploy coercive force should the need be. So they had the security. So for example, if you go to most of the places, they have something called the Ahimfie police. And I'm sure in the various traditional communities or ethnic groups, there will also be equivalent of security officers kept by the chief in order to enforce the decrees of the chief. If for nothing at all, we know the executioners, Abrafo, right? The executioners are also the same as the Ahimfie police because the executioners are police, in the traditional setting, so to speak. So they will ensure that people comply with orders of the chief. Another discernible common feature in the traditional governance arrangement is the link between the spiritual and the physical. So in the traditional governance system, you see a link between what you call the spiritual world and then the physical world. And if you look at how authority was exercised, the chief as the head was often seen as embodiment of being the intermediary between the spiritual world and then the physical world. We also notice that in the various traditional constitutional establishment prior to colonial administration, the people had the power to distill a chief or to deskin a chief. There was a process by which a chief could be removed from the stool or from the skin. Then we also noticed that there was a place for women in traditional governance. So we had the position of the Queen Mother, who served as the chief advisor. Or if you've heard of that kind of something called the Abrewetia. The Abrewetia, like the old woman, supposedly, who is supposed to be consulted. And by analogy, that is like the Queen Mother. So if there is anything which the chief is going to do, the chief will need to consult, or the Queen Mother can call the chief behind the scene and advise the chief, as it were. Again, in the traditional society too, we had a clear system for selection of leaders. We had a clear selection process for leaders. It's not the case that anybody got up and then assumed a position of choice, as it were. No. We had a clear procedure as to what should be done before you could become a legitimate leader. And you must also meet certain qualifying criteria, must possess certain qualities, and so on and so forth. Now, how did the modern state of Ghana evolve? The name of our country, Ghana, you notice, was adopted, or it was unveiled on the day that independence was declared. So 6 March 1957. And you notice that when we attained independence, we did not have full republican status. We had limited political independence in the sense that we're still having the monarch of England as our head of state, ceremonial head of state. And the head of government is what we selected from our people. But then, about 3 years later, we made a major move to extricate, to release ourselves from the last vestiges of colonial shackles by trying to jettison any umbilical cord with the Metropolitan Colonial Authority, that we do not want to have the monarch of United Kingdom or England as our head of state. We want to select our own head of state, which shall be commander-in-chief of the armed forces. So that was made possible by attainment of republican status on 1st July 1960. And for the records, before we unveiled our new name, Ghana, on attainment of independence 6 March 1957, and prior to that, the territory we now call Ghana was called the Gold Coast Colony. But we need to properly contextualize the history and the geography as far as the Gold Coast Colony is concerned. At certain times in our evolution, Gold Coast Colony meant strictly only the areas around the forts and castles. So the forts and castles, like the forts and castles were those like strong, buildings, settlements which had been erected by the colonizers. Initially, as you go through the history, they were meant for trading purposes. It was later on that they decided to put it to some other uses in terms of having political sphere of influence, and hence the inauguration of the colonial era, as we noticed. And again, for a long time, what we call the Gold Coast Colony never included Ashanti Protectorate and then the Northern Territories. The Ashanti Protectorate was initially not part of the Gold Coast Colony. The Northern Territories, what we call like the northern regions, now divided into about 5 regions or so, were also not part of the colonies, what we call like the Gold Coast Colony. It was later on that they were roped into the Gold Coast Colony. Another historical point worth noting is that from 1866 to 1874, the administration of the Gold Coast was united with that of Sierra Leone, Lagos, and Gambia. under a government known as the government of our West African settlements. So for about 8 years, Gold Coast Colony, Sierra Leone, Lagos, Gambia were all treated as, if you like, one administrative establishment. Now, in 1843, the British Parliament, if I say British Parliament, and let me make this point, the British Parliament here refers to the Parliament of the home country of the colonialists, like in Great Britain. That is the British Parliament. We are not talking about the Legislative Council and later the Legislative Assembly and Parliament now. No, we are not talking about that. We are talking about the Parliament of the home country of the colonizer. So in 1843, the British Parliament passed two major pieces of legislation known as, first, the British Settlement Act 1843 and the Foreign Jurisdiction Act 1843. Let's say a few words about each of them. The British Settlement Act 1873 enabled orders in council to be made by providing for establishment of laws, institution and ordinance for the peace, order, and government of Her Majesty's subjects and others within the settlements on the African coast. Now, let's put it in context. Before how this legislation came to be, because we've already made the point that constitutional making or constitutional evolution was often in response to some political problems. So what was the situation which paved the way for enactment of the British Settlement Act and subsequently the Foreign Jurisdiction Act? Now, the point to note is that initially, the British interests or possession along our coast consisted mainly of the forts. And the administration of same for a period of 20 years, that is from 1800 to 1820, were largely in the hands of the merchants, so to speak. But on 7th May 1821, the literature indicates that the merchants that we call like the company who were running administration of the force and castle. Now, the administration was dissolved. And for that matter, the Gold Coast was added to the administration responsible for Sierra Leone, responsible for Gambia and Lagos. So that was the situation. Now, the Ashantis were warring the British around this time. And they had actually engaged the British forces. And the governor at the time, Sir Charles McCarthy, who had come from Sierra Leone to take charge of the operations, was killed in 1824 in a war with the Ashantis. Now, the British were very angry that they had suffered such defeat and humiliation. And for that matter, they sought to fight back the Ashantis. And they avenged the Ashantis in the Battle of Dodowa in the present-day Greater Accra. And this made the British government decide to withdraw from the Gold Coast. The merchants, that is the traders, were not happy with the decision of the British government to withdraw. And for that matter, they petitioned the British government to once more take charge of administration of the British force and settlements. The British government allowed the merchants to take over. And the committee, which was put in place to see to the administration of the force and castle, was put under the chairmanship of Captain George McLean, which we all know. And McLean administration was quite successful in terms of spreading the British sphere of influence. But this also angered the traditional rulers of the coastal states. And two main reasons have been assigned for the resentment of the traditional rulers of the coastal states. The first reason arose out of the abolition of the slave trade, which led to a loss of revenue to the chiefs. The chiefs were actually enjoying the slave trade and were making revenue and getting, schnapp and other high quality alcoholic drinks from them. So they're not happy that the McLean administration was actually abolishing slave trade and so on. The second reason was that the merchants were refusing to pay ground rent to the traditional owners of the land on which the forts and settlement have been built. And the British administration reason for refusing to pay the ground rent to the traditional authorities was that they thought they had acquired freehold or allodial title of this land as a result of the British victory over the Ashantis in the Battle of Dodowa in 1826. Now, the grievances of the chiefs of the coastal areas were escalated to the British government. So this was forwarded to the British government in UK. So in response to the complaints or the grievances by these traditional rulers along the coast, a select committee of the House of Commons, that is the British Parliament, the lower house, a select committee was appointed by the British government to investigate the situation in 1843. And the main finding of the committee vindicated the chiefs, saying that the chiefs were right. So the committee found that George McLean's extension of his administration beyond the British holding, that is the First and Castle, though fair, had no legal basis and was therefore irregular. So McLean was behaving like the proverbial octopus, spreading his tentacle here and there to spread the British sphere of political influence along the coast, beyond the First and Castle. So the Select Committee of the House of Commons made two major recommendations. One, that the British government should resume direct control of the British interests. And two, the position should be regularized through the signing of treaties of friendship with the aggrieved chiefs. Now, as a result of the report of the Select Committee in 1843, these two legislation were passed by the British government. That's the British Settlements Act of 1843. And then the Foreign Jurisdiction Act of 1843. Now, the British Settlement Act, as you have said, provided legal basis for the colonial administration to make laws which, within the framework of the metropolitan legal system of Great Britain, will be recognized as having legal efficacy for purposes of governance in the colonial territory. So that is why, because mind you, the Select Committee has said that what George McLean and his people were doing in terms of administration had no legal basis. So that was cured by this British Settlement Act. And then again, the Foreign Jurisdiction Act, the same year, 1843, authorized the exercise of political powers acquired by agreement or usage in territories which they had not acquired by cession or conquest. So it's not, if you look at let's say the Battle of Edward, the British were successful. And for that matter, whichever areas that they had defeated or their opponents, technically, they will assume control over those areas and they can establish themselves as rulers because they fought war and were successful. But then there are also places that the British have not had to engage in war. So how could those places be legitimately brought under colonial administration? It is for those type of places that the Foreign Jurisdiction Act of 1843 sought to provide the necessary legitimacy. Another important development is that on 6 March 1844, a major effort was made to try and consolidate, that is to put together all the various friendship treaties which have been signed with the coastal states. And the literature indicates that as many as 11 friendship treaties have been signed with the coastal states by the Lieutenant Governor, Commander Hill, between 1843 and 1844. So this Lieutenant Governor was like the head of the colonial administration in the colony on behalf of the Secretary of State, that is the Foreign Minister in Britain, as it were. Now, in order to ensure simplicity, coherence, the various 11 or the 11 friendship treaties were brought together in a composite document known as the Bond of 1844. The Bond of 1844, which was executed on 6 March. And let's pay attention to the date. No, 6 March 1844, we had the major agreement known as like the Bond of 1844, executed between the Crown. When I say like the Crown, that is the British administration, the British government, and some fancy chiefs. And the literature indicates about 8 fancy chiefs. And this is what was contained in the Bond of 1844, signed between the British government and the fancy chiefs on 6 March. I'm quoting the exact wording. And Professor Umado has reproduced it in his book. If you go to page 42 and 43, they are there. Quote, whereas the power and jurisdiction have been exercised for on behalf of Her Majesty the Queen of Great Britain and Ireland within diverse countries and places adjacent to Her Majesty's forts and settlements in the Gold Coast, we, chiefs of countries and places so referred to and adjacent to the said forts and settlements, do hereby acknowledge that power and jurisdiction and declare that the first objects of law are the protection of individuals and property. 2, human sacrifices and other barbarous customs, such as panyarring, are abomination and contrary to law. And when we say panyarring, panyarring simply refers to a practice whereby relations of a wanted person are detained by the law enforcement agencies to induce their surrender or production. For example, just recently, you heard in the news that the former finance minister, Mr. Kenneth Ofori-Atta, was being sought by the Office of Special Prosecutor, and that he had been declared wanted or something like that. I don't know the details or legitimacy of that, but as what is in the news, is anything to go by, then that is how it is. And for example, if you are applying the panyarring, you say that, okay, if we cannot find the person you're looking for, then you take custody of his close relation until he himself surfaces and then they are released. So that was the practice known as the panyarring in the past, and it was abolished by the Bond of 1844. The third clause in the Bond of 1844 ran as follows, quote, murders, robberies, and other crimes and offenses will be tried and inquired of before the Queen's judicial officers and the chiefs of the districts, molding the customs of the country to the general principles of British law. So, if you look at the Bond of 1844, you notice that it was an attempt to bring some legitimacy to what the colonial administration have been doing, and also to try and discourage the traditional authorities from certain harmful practices, including just handing death penalty on, let's say, people not through what the colonizers call their due process. And that is why they said that certain serious crimes, like murder, robberies, and other offenses, will now be tried by not the chiefs only, but judicial officers of the colonial authority. And the chiefs are also supposed to mold their customary law to reflect the general principles of British law. So that was a bit like insulting, isn't it? Because why should you adjust your local law to reflect somebody's law? Is it because they think he's superior or better than you or something like that? So that was the trouble. But that is what the bond of 1844 actually signifies. And I said you should note the date, the 6th March, because our independence too will be declared on the 6th March. So an argument has been made by some commentators that, in a sense, the bond of 1844 constituted official acknowledgement of the power and jurisdiction of the British around the forts and settlements. And also to the extent that the chiefs had agreed to the exercise of judicial power in the mode of identity custom to British law. It's like they had surrendered their independence in a sense. And that is why our political independence in 1957 was actually made to coincide with the 6th March. So we have our independence 6th March 1957. Some interesting correlation with the 6th March 1844 bond. Now, in 1874, a royal charter was passed to create what we call the Gold Coast colony. The Gold Coast colony. That's 1874. And this happened on 24th July. So 24th July 1874, we had the royal charter, which said that now the Gold Coast colony is to be established and separated from the administration of the other West African settlements going from Sierra Leone, except Lagos colony, which will future become Nigeria. So initially, Lagos colony the future Nigeria was included in the Gold Coast colony by reason of the 1874 Royal Charter. Now, so therefore, the colony comprised 3 main divisions: the Western, Central, and the Eastern provinces. So let's keep that in mind. So the Eastern province was made up of the Ga Adabes, Dakan, the tribes of Southern Volta region, the Anglos. The Western province remained unchanged until 2019. It was divided into 2 regions. When we have the Western and then the Western North. And then we have the Central province. It has also remained unchanged. So the Central province, as we know it, has been as it was from the colonial era. And we also have 2 regions that were carved out of the Eastern province: Greater Accra region and then the Eastern region. And then the Anglos were added to the British Territory of Togoland to form the Volta region. So originally, the Anglos were part of the colony, but the other parts of the Volta region were not part of the colony. They were under the control of Germany. But when Germany was defeated in the Second World War, Germany was made to lose all its overseas assets, including its colonies. And then they became like the a protected or like a trust property under the auspices of the United Nations. So when Ghana was about to attain independence, it was necessary to let them exercise what in modern public international law is known as a right to self-determination, for them to make a conscious choice. Do they want to remain on their own? Do they want to remain part of the Gold Coast, which was on the threshold of attaining independence? So a plebiscite was actually held, a form of like a referendum, and they overwhelmingly voted to join Gold Coast, which was becoming independent Ghana. So that is the story. Now, the Supreme Court was established in 1876 as the Supreme Court of Judicature for the Gold Coast Colony. So, as we speak now, Her Ladyship, the Chief Justice, has set up like a committee, which yours truly is part of. We are planning to, celebrate in a grand style the 125 years anniversary of the establishment of the Supreme Court. And the 125 years is reckoned from this critical legislation that the Supreme Court, the Supreme Court Ordinance of 1876, which established this Supreme Court. So, I think by 1976, it will have done how many years? Is it 100 years? Yeah. So 1876. So by 1976, that was 100 years. So now from 1976 up to 2026, which will be like next year, that will be how many years? That's 150 years. Yeah, 150 years. So we are going to celebrate the 150 years anniversary of the founding or the establishment of the Supreme Court, Ghana. Now, the Supreme Court Ordinance is of some significance, and for which reason you should, of course, in your Ghana legal system, you have come across it. And in my own book, the Ghana Legal System and Legal Method, if you don't have copies, there are 2 volumes, volume 1, volume 2. When you are discussing the sources of law, the core structure, the history of the legal system, and then some significant searchlight is thrown that. So, some of the importance of the 1876 Supreme Court Ordinance include the sources of law which were to be applied. But of course, you remember how it treated customary law. He said that the customary law was to be treated more or less as a question of fact, unless it has been treated over and over again. It becomes so notorious that the court can take it for granted that it is well known. And how subsequently the Privy Council, the famous case of Angu versus what, will give judicial imprimatur to that view, that question as to the existence of customary law is a question of fact. It's not a question of law. And that viewpoint, as you recall, will remain true for many years until 1960, when we attain a publican status, and then we have like the Courts Act, which says that henceforth, question as to existence of a rule of custom is not a question of fact, it's a question of law. And it will have to be established just like any rule of law is established by the courts. Now, another milestone in the historical evolution is that the seat of government moved from Cape Coast to Accra in 1877. So let's keep that in mind. The capital town of Ghana was initially in Cape Coast. So that was, Cape Coast was where the action was for many years. And then in 1877, there was a change. And they moved everything to what they call like the Christianburg, which was also used as a seat of government for many years until the Flagstaff House was built and later on the Jubilee House, as it were. So maybe in a pictorial form, this is a rough sketch of the historical journey. So as you can see, you have the pre-independence constitutional history. So the bond of 1844 there, the Royal Charter, which would actually officially confirm the establishment of the colonies. So we have the 1866 Constitution, 1901 Constitution, 1925 Constitution. Before that, 1874 Constitution, the 1901 Constitution, 1925 Constitution, before 1925, we had like the 1916 Clifford Constitution, the 1925 Guggisberg Constitution, 1946 Alabama's Constitution, 1951 Constitution, 1954 Constitution, and eventually the independence of Constitution. So that has been like the movement. So let's say a few words about each of these institutions. So let's take the 1850 Constitution. The 1850 Constitution, promulgated by the Royal Charter, effectively provided for severance of Gold Coast from Sierra Leone. So Gold Coast was decoupled from Sierra Leone. Gold Coast is no longer treated as being part of colonial administration for Sierra Leone, Gold Coast, and all that. And it also gave, or it established a separate governor for the Gold Coast. And the first governor from that is the Governor Hill, who also had at his disposal legislative and executive council. So the legislative council and that constitution consisted of the governor and at least two other persons designated by royal instructions or warrants. So trying to avoid, if we like, authoritarianism or totalitarianism or dictatorship by just one person. That is why the constitution ensured that executive authority will not be exercised by just only the governor, but the governor will have to work with some other people, the executive council. Then the legislative council consists of the governor and at least two other persons, as we have said. But the challenge is that the governor was part of the executive, at the same time part of the legislature. I mean, that was unsurprising if one considered the fact that in the metropolitan country, that is in the Great Britain, where these colonialists are coming from, that is essentially the model of governance they run, because they have the prime minister. The prime minister is head of the executive arm of government, and at the same time is a member of parliament, leader of government business in parliament, so to speak. Now, the Royal Charter of 1850 also authorized the governor to summon an executive council to assist and advise him in administration of government, as we have already indicated. Now, we also had another constitutional development in 1866, and that revoked the Charter of 1850. And it again united the Gold Coast together with the Sierra Leone, Lagos, and the Gambia under the governor of West African settlements. It preserved the existing Gold Coast Ordinance and also the Legislative Council. That is all the laws which have been made by the old Legislative Council, and then the various ordinances made were to be retained. The Executive Council ceased to exist, and the Supreme Court was abolished in 1866 and replaced by the Court of Civil and Criminal Justice, presided over by a chief magistrate. Now, this constitutional arrangement of 1866 was abolished or significantly modified insofar as it applied to the Gold Coast and Lagos with the adoption of the Constitution of 1874. And that constituted the Gold Coast into separate colony under the title of the Gold Coast Colony, and provided for governor, legislative, executive council, and essentially repeated what pertained under the terms of the Charter of 1850 with slight variation or modifications. Then we also have the Constitution of 1901, which laid down for the first time geographical boundaries of the colony and annexed other territories in the colony, which did not already form part of Her Majesty's dominions. So the annexed territories form part and parcel of the colony, and all existing laws were applied to them. Now, this order in council, which ushered the 1901 Constitution, actually came into force on 1st January 1902, but was subsequently amended by substitution of a more precise boundaries by the Gold Coast Boundary Order in Council 1906. Now, let me give you a little bit of explanation as far as the Order in Council and all those things are concerned. Now, within the colonial context, we had the British Parliament sitting in Britain. It will make the relevant acts of Parliament. Sometimes it could make a legislation of general application, meaning that that legislation applies to the whole of British Empire. All the colonies, it applies to you. And that is why, if you remember your Ghana legal system, when you are learning the Courts Act, the sources of law, especially if you look at the Courts Act of 1993 at 459, towards the end, there's a table of what we call the statutes of general application. That is statutes which were applicable to the whole of the colonies, if you remember. So that is the genesis. And again, the British Parliament could also make a specific legislation for particular colony, or make a legislation which will give the foreign minister or the Secretary of State the power to actually make certain orders or make certain authorities for them to make no specific rules or regulation which will govern particular colonies. Then we had the Clifford Constitution of 1916. And the Clifford Constitution continued the existing span of earlier constitutions. The Executive Council were maintained, but Legislative Council was enlarged to 22, and it had both official and non-official members. So this included chiefs and two intelligentsias. That is the two local, educated persons. They were called intelligentsia. But both councils were largely advisory, and the governor was given veto power, meaning that the governor could veto, that is, override the views of the Executive Council and the Legislative Council in appropriate cases. Now let's say a few words about Guggisberg Constitution. In my view, the Guggisberg Constitution is quite monumental and a phenomenon which should deserve a bit of attention. Because the Guggisberg Constitution of 1925 brought major developments, major changes. Now, point to note is that there had been various agitation. Because this is not like a history class and we have a limited time, we have actually been quite snappy in our historical excursions. And we even jump what we call the Aboriginal Rights Protection Society, if you remember, of 1897, which in your land law, if you remember the Crown bills, Crown lands bills, which was seeking to vest all on occupied land in the Crown, that is the British government. And the famous declaration, in cases and those writings of Mensa Saba, that there are no ownerless land in Ghana, if you remember that. Yeah. So there have been various agitation among the intelligentsia or the elite for changes in the governance arrangement in the constitution. And one major one was that which culminated in the constitution known as the Guggisberg Constitution of 1925. So as I indicated, we have had the Aboriginal Rights Protection Society formed on 4 August 1897, fight against the decision of the government to vest all lands in the state. Maybe in modern day, we call that the eminent domain, if we like. But of course, that was not proper eminent domain, because eminent domain here means compulsory acquisition. Compulsory acquisition, if you look at Article 20 of the 1993 Constitution, requires certain parameters to be met and certain protections be afforded the owners of the land, which are going to compulsorily acquire. But that was not the case as far as the lands bill that was resisted by the Aboriginal Rights Protection Society of 1887 really was. But as I indicated, as a result of the agitation of the Aboriginal Rights Protection Society, the land bill was withdrawn. And if you look at the scholars like the late Emeritus Professor Jandor, he will observe that the Guggisberg Constitution resulted from two separate but related developments in the colony. The first was pressure for constitutional reform through vehicles like the Aboriginal Representative Society and the West Africa-wide National Congress of British West Africa. So these agitators for constitutional reform changed the political landscape in the colony. The second factor was the colonial government response to the agitators. So there were two separate issues on the agenda of the agitators, namely representativeness and accountability of the government in the colony to the people, that the people should be given more representation. And again, the colonial government should be made more accountable to the people. So these were the two main concerns of the agitators, as it were, and that is what will find its way into the various provisions which we witnessed in the 1925 constitution called the Guggisberg Constitution. So let us keep that in mind. The second element was an effort to curb the growing influence of the mainly urban-based reformists. If you look at the various constitutional amendments which have been evolving, most of the changes had favored the elites who were in the cities. But the traditional leaders in the various communities had not adequately been represented. And that was not right, because the traditional leaders felt that they were the legitimate representatives of the people. And for that matter, if you are going to establish any legislative council or any council for governance, they should be given adequate seats, adequate representation. And this point, keep it at the back of your mind. That challenge has been with us through to decentralization policy when it comes to the district assemblies and metropolitan assembly, municipal assemblies, where we have a tension. If you go to most of the communities, the chiefs are seen as the natural leaders. Nevertheless, you get a modern constitutional arrangement calling somebody district chief executive, calling somebody regional minister or metropolitan chief executive, municipal chief executives. Now, between these chief executives and the traditional leader, who is naturally respected and seen as legitimate by the people, is certainly the traditional leaders. So that is where the challenge is. So if you are going to reform our local government, a lot of thought will have to be given to that particular aspect. So that is very important. So the British government created a platform in response to these concerns for greater consultation with the chiefs outside the Legislative Council. And this platform was known as the Provincial Council of Chiefs, now Regional Houses of Chiefs. So this is how we got like the Regional Houses of Chiefs. Going back to the colonial era, starting from 1925 Guggisberg Constitution, there had been the Provisional Council of Chiefs, which was supposed to be a consultative forum for traditional leaders to make input into issues of governance. Now, apart from these two major additions, it is said that the 1925 constitutional arrangements largely consolidated the domination of the governmental machinery by the executive. And this 1925 Constitution was actually contained in 3 separate documents. If we look at the literature, the Gold Coast Colony Legislative Council Order in Council, dated 8th April 1925. So what this instrument sought to do was to expand the council, which at first was established in 1850, and also expanded in 1916. Then the second document, in which the 1925 Constitution was contained, is known as Letters Patent, dated 23rd May 1925, which formally established the office of governor, who was also the commander-in-chief. So the Letters Patent of May 1925 established the office of governor and declared that the governor is also the commander-in-chief. So later on, when we attain independence and Republican status, we get a president, then he also becomes the commander-in-chief. Then the third instrument in which the Guggisberg Constitution was located is the Royal Instructions of 23rd May 1925, which established the Executive Council and placed specific limitations on the legislative powers of the Legislative Council. Example, mode of making legislation known as ordinances. So all these were contained in that royal instruction. What are the main features of the 1925 Guggisberg Constitution? So Section 3 of the Order in Council established a legislative council which consisted of 15 official members, 14 unofficial members, and the governor. So the legislative council was made up of 29 members plus the governor. And the 29, 15 were official members and 14 were unofficial members. So if you look at Section 4 of the Guggisberg Constitution, it explains the official members as follows. So 5 members of the Executive Council, the Secretary of State, the Attorney General, the Treasurer, Director of Medical and Sanitation Service, and the Secretary of Native Affairs. So these are the official members. And also 18 officers holding important posts such as Director of Public Works, Comptroller of Customs, and Director of Education. And any 2 persons holding public office nominated by the governor. So these constituted the 15 official members. And then we have the unofficial members. They're composed of 6 provincial members, 3 for the Eastern Province, 2 for the Central Province, and 1 for the Western Province. And then 3 municipal members, 1 each for Accra, Cape Coast, and Sekondi. And then 5, mind you, all this while, Kumasi or Ashanti has not become part of this colonial constitutional arrangements. It will be later in the 1934 going. And 5 Europeans made up of 1 representative of the Chamber of Commerce, 1 mining member representing the mining industry, and 3 Europeans appointed by the governor. Yeah, so in roughly, I mean, this was like the picture. Another radical change introduced by the 1925 Constitution was what we call the elective principle. Elective principle was introduced into the Legislative Council. So the 3 representatives from the various municipalities were directly elected, and those of the province or the colony were indirectly elected. Again, provincial councils was another outstanding feature of the Guggisberg Constitution. Now, the provincial council, as we have seen, was given prominence and also gave recognition to the chiefs. Each of the three provinces had its own provincial council of chiefs, and the chiefs were supposed to use that forum to make inputs into governance, as it were. Yeah, so at least this gives you a bird's eye view of the Guggisberg Constitution. So let's say a few words about the 1946 Constitution, LLB's Constitution. The LLB's Constitution, again, was as a result of agitation for constitutional reform, as we have already noted. And in terms of progress, which have been made by agitators for reform with respect to what we see in the LLB's Constitution of 1946, was the introduction of representative government, very important, for both the colony and Asante. That is the Asante territory, which has not become like part of the colony, strictly speaking. So for the very first time, since 1850, there was an African majority introduced into the Legislative Council. And that was a big thing. It was a big reform by the colonial government, because if you examine the numerical composition of the Executive Council, the Legislative Council, across the various colonial constitution before 1925, you notice that the Europeans were often in dominance or majority. But the 1925 Constitution did not only introduce representative government, it also ensured African majority into the legislative council, into the legislature, as it were. And the Ban's Constitution was contained in an instrument officially entitled the Gold Coast Colony and Ashanti, into brackets, Legislative Council, Order in Council, dated 19 February 1946. What were the main features or characteristics of the Constitution? So, Legislative Council was given constitutional powers to legislate for Ashanti. So until this time, the Legislative Council would not make a law to actually apply to the Asante territory. Also, elected members increased from 11 to 18. There was abandonment of the legislative majority principle, an introduction of an African unofficial majority into the Legislative Council. So the council was composed of the following: the governor or representative appointed by the governor as the president of the Legislative Council, 6 ex-official members, 18 elected members, all Africans based on electoral colleges, 6 nominated members mixed European and African by the governor. There was also innovation of giving majority to the African unofficial members on the Standing Finance Committee, contrary to the convention whereby government had a controlling voice in financial matters. So for now, Africans were having a bigger say when it comes to how taxes are imposed, how revenue is utilized. Africans were having greater say. Also, for the first time, representatives from Asante territory were included. So all this while Asante territory are not included in the various legislative executive councils. But these representatives from the Asante territory had to be persons who owed allegiance to the golden stool. That is the Asante Hene. And they were 4 in number. So this should also tell you something that if you look at the Constitution 1992, you will notice that it was specifically mentioned the Asante Hene, that the paramount chief. It has a background, but if you don't appreciate history, you will just take some of these matters at the surface, and then you create unnecessary problems. It has to do with historically how some of these communities have actually been configured and organized. And the colonial administration, even in its various constitutional reform, as we have seen through the Benz Constitution of 1946, actually recognized that the governor still retain twin powers of veto or the reserve powers. That is reservation over legislation. The Benz Constitution also saw inclusion of representatives of the Joint Provincial Council of Chiefs and their express adoption as an integral part of the constitutional machinery. But these had to be paramount chiefs, recognized as such by the government or person who owed allegiance according to native customary law in the respective provinces. So here you see how gradually the chiefs are being given a greater role in governance. The Alandban Constitution of 1946 also witnessed conversion of Legislative Council from being a kind of advisory body into a representative legislature. So now the Legislative Council was not just advisory body, it was a proper legislature which could make laws that will have binding effect. The 46th Constitution also provided for the establishment of an Economic Development Committee, Central Advisory Committee, one each for education, rural development, and agriculture. But if you look at the 46th Constitution closely, the elective principle was qualified or specially calibrated in a certain way. If you look at section 32 of that constitution, for example, it stipulated language and property qualification for those who are to be elected from the municipal members, that is from Accra, Cape Coast, Sekondi, and Kumasi, that you needed to have the ability to speak and write English language. And then you also needed to have a property of not less than 200 pounds. So if you were a man of straw, if you were a poor man like me, you couldn't be elected to represent these municipal members, as it were. But the intention behind the property qualification may have been to ensure that only people of substance or people with material interests at stake in the country were elected to a council. I think it will not be a bad idea if you are to rethink that to be elected a member of parliament. But the other fear is also that if you are not careful, you establish what do you call the oligarchy, or the rule by the rich, the elites. Otherwise, one will argue that if someone is going to be a member of parliament and he has to demonstrate a certain property qualification, would that guarantee more responsibility and better attention to interests of the nation? Well, maybe things that we have to ponder. We don't have any easy or straightforward answers. So let's keep this at the back of our mind because we are having a broad brush approach. We cannot spend all the time on one constitution. Okay, because of time and what is left, we cannot finish in just 10 or 20 minutes. So we have to pause here and continue our historical evolution of Ghana's constitution at the next class. So at this stage, I'm going to stop recording and then release the mic for you to contribute towards the discussion.